Welcome to our discussion on foreclosure investing in the state of Maryland. In this session, we are going to concentrate our discussion on the Maryland Protection of Homeowners and Foreclosure Act, commonly referred to as PHIFA, and more specifically demonstrating the myths being advanced by self-proclaimed experts in this law for the purpose of promoting their self-interest and how following the advice of these experts can land you in jail. Now, it is not my intention to badmouth any of these folks or to hurt them in any way. The truth is that this law has been newly amended and there are bound to be mistakes on interpretation by everyone. While one of the individuals is using the complexity of this law to promote his or her self-interest, I do believe that this individual, as off the mark as he or she is, genuinely wants to get it right. As a result, I have masked the voices to preserve their anonymity. As a result of this voice masking, some of the audio clips may be difficult to understand. Please accept my apologies for that. With that in mind, we are ready to begin to dispel our first myth. Please listen to this clip.
An investor, I want to go out, I want to invest in real estate. You're talking about foreclosure consultants, and I know you've already covered this, but let's just make it really clear here on the call tonight. It sounds like I can't be a foreclosure consultant and buy the property, so what do I do?
Like I was saying earlier, you need to look at Section 7301, and you need to go through what are the definitions of a foreclosure consultant. What does that mean? And then also look at what are the definitions of a consulting service. Because you'll see one of the things in a consulting service, like I said, is to have contact and speak to any creditor. Any creditor, it doesn't even have to be the mortgage company, but any creditor. They have a judgment against them that needs to be cleared up or negotiated, or a second lien on the property, or there's something else in there that is impeding the sale of that property. If you're going to be in contact with that person on behalf of the owner, now you become a foreclosure consultant. So there are times where you're going to want to bring a consultant in on the deal just to be on the safe side, and it's like anything else. It used to be that you didn't need to get an appraisal on your property to get a mortgage, and now it's just become standard practice, and it's an expense that you automatically take into consideration when you're purchasing a piece of property. Well, you're going to have to take into consideration that you may need a foreclosure consultant, and you may need to pay for that service, and just build it into the cost of what your offer is going to be to purchase that property, instead of trying to find a way around this law. Find the fastest, easiest, least expensive way to work within the law.
So this brings us to common PHIFA myth number 1. Contacting a creditor makes one a foreclosure consultant. This is indeed a myth. This statement is false. And let me explain why. The first place we're going to look is to the Protection of Homeowners and Foreclosure Act itself. And we're going to look more specifically at Section 7-301C, which defines the foreclosure consultant. Foreclosure consultant means a person who's, number 1, solicits or contacts a homeowner in writing, in person, or through any electronic or telecommunications medium, and directly or indirectly makes a representation or offer to perform any service that the person represents will, 1, stop, enjoin, delay, void, set aside, annul, stay, or postpone a foreclosure sale. 2, obtain a forbearance from any servicer, beneficiary, or mortgagee. 3, assist the homeowner to exercise a right of reinstatement provided in the loan documents, or refinance a loan that is in foreclosure or for which a notice of foreclosure proceedings has been published. 4, obtain an extension of the period within which the homeowner may reinstate the homeowner's obligation or extend the deadline to object to a ratification. 5, obtain a waiver of an acceleration clause contained in any promissory note or contract secured by a mortgage on a residence in default or contained in the mortgage. 6, assist the homeowner to obtain a loan or advance of funds. 7, avoid or ameliorate the impairment of the homeowner's credit resulting from the filing of an order to docket or a petition to foreclose or the conduct of a foreclosure sale. 8, save the homeowner's residence from foreclosure. 9, purchase or obtain an option to purchase a homeowner's residence within 20 days of an advertised or docketed foreclosure sale. Or 10, arrange for the homeowner to become a lessee or renter entitled to continue to reside in the homeowner's residence after a sale or transfer. Or 2. Systematically contacts the owners of residences in default to offer foreclosure consulting services. As you can see, there is absolutely nothing in the definition of a foreclosure consultant that says anything about contacting creditors on behalf of a homeowner. However, contacting creditors on behalf of a homeowner is a foreclosure consulting service. So the question is, if you contact a creditor on behalf of a homeowner, are you a foreclosure consultant? The answer to that question is no. And the reason why it is no is because it boils down to a question of intent. We go back to the definition, the second part of the definition of a foreclosure consultant, where it says systematically contacts owners of residences in default to offer foreclosure consulting services. Basically, what this means is that you are deliberately contacting the homeowner of a residence in default for the purpose of offering foreclosure consulting services. However, the actual rendering of those services does not necessarily mean that you are a foreclosure consultant. So the question remains, if you have not offered to provide any of these services, if it is a residence in default, and in the period of doing your due diligence you realize that the price that you can pay will not pay the lien off in full. If that is the case, then a short sale would be necessary. So the question is, if you contact the creditor in order to do a short sale, does that mean you are a foreclosure consultant? And again, the answer to that is no, and in support of that answer, we go to a letter that we received from one of the lawmakers that was involved in the drafting and subsequent passage of this law. The lawmaker's response was this: Bruce, sorry for not responding earlier, but things have been very hectic. As to your questions, number 1, the key question is whether someone is a foreclosure consultant or not. Look to the definition section for foreclosure consultant. Clearly, he's talking about the first part of the definition here. He is not talking about the services. Anyone who does any of those things is a consultant. While there is a lot of overlap, that is not the same thing as foreclosure consulting services. If a consultant provides the relevant services, then all the provisions apply. And this is what's really important here. On the other hand, it is possible to do some of the things that fall under the definition of services without being a consultant. This brings us to common PHIFA myth number 2. You want to bring a foreclosure consultant in on the deal. Again, this is a myth, and the answer is false. And in fact, in reality, you cannot, and here's why. Again, we go back to the Maryland Protection of Homeowners and Foreclosure Act, and this time we are in Section 7-309B. And right in here you can see, and I'm just going to highlight it for you right here, a foreclosure consultant owes the same duty of care to a homeowner as a licensed real estate broker owes a client under Section 17-532 of the Business Occupations and Professions article. What this means is that the foreclosure consultant is hired by the homeowner, not by the buyer. And the foreclosure consultant has a fiduciary responsibility to the homeowner and not to the buyer. And therefore the buyer cannot hire the foreclosure consultant for the homeowner.